Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
A few days ago, I argued ObamaCare at the Federal Court of Appeals. I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Shawn Akers, the dean of the Helms School of Government at Liberty University. Shawn, a few days ago, I was at the Fourth Circuit Court of Appeals in Richmond, Virginia, and I argued before a panel of 3 judges regarding the so-called ObamaCare law. My argument was scheduled to be 20 minutes, with 20 minutes for the United States. But the judges, in an unusual situation that I've rarely seen happen before, doubled the time for the argument. And actually, I argued for twice that time. The entire argument for Liberty University et al. Versus Geithner was an hour and a half. And then after that, of course, the second case was argued, and that was the Commonwealth of Virginia. Theirs was 20 minutes and 20 minutes aside, but theirs focused not on the merits, but on whether they had the right to even bring the lawsuit in the first place. But it was a very tough panel. A decision should come down within the next 45 days or so, which will be very quick. And from there, the next step should be the United States Supreme Court.
Matt, you are really blazing the trail here. It is amazing to me that as we look out, Obamacare has been under attack by a variety of states and interests all across the nation, but somehow, with God's favor and a very aggressive calendar, you managed to get the very first private case on Obamacare before a court of appeals. Now, when you say that they addressed yours on the merits where they addressed the state's case otherwise, what do you mean by that?
Well, our case challenged the individual and the employer mandate, and we have 2 primary arguments. One, that Congress lacks the authority to pass this, and secondly, it violates other constitutional protections. We've got a chance to argue all of those constitutional issues, and we can talk about the implications of those issues later. The Virginia case, in its lawsuit, filed a suit against the individual, not the employer mandate. And they also argue that Congress lacks authority to pass the individual mandate. They didn't argue that there's other constitutional reasons against it. But our case was able to argue the actual merits, whether it is constitutional and why we believe it's not constitutional. Their case, the Virginia case, was on whether or not Virginia has the right to challenge the individual mandate as a state. We clearly do, because we represent both an employer, Liberty University, for the employer mandate, and we represent 2 private individuals who are both affected by this individual mandate. The question is, and that's what the issue was that was argued before the court on Virginia's case, is whether they, the state of Virginia, have the right to challenge the individual mandate on behalf of its citizens. And there was some significant skepticism among the judges, and I don't know where it will come down. But if, for example, the court ultimately were to rule against Virginia, finding that they don't have standing to bring the case, then they won't reach the merits in the Virginia case. And the only thing that Virginia could take to the Supreme Court is whether they have standing, not whether the law is constitutional or not. Our case, no matter which way it goes, whether they rule for or against the law, will reach the merits, whether it's constitutional. They'll either say that it's constitutional or they'll say that it's not constitutional in their view. And then, of course, that's the merits, that's the heart of the case, and that is what we'll be able to take to the United States Supreme Court. So we'll have to just see how it comes down.
Yeah. Now, the stage that it's in now, if I understand you right, Matt, is that whether this court rules for you or against you, the other side's always likely to appeal. If they were to rule against us, we would file a writ for certiorari with the United States Supreme Court, and it's very likely that if you won at this level, that the other side would file the same kind of writ or some similar proceeding to take the case further. So this is one of those cases that I think is reasonably bound for the United States Supreme Court.
Well, you know, there's only about 1 to 1.5% of all the cases that are requested for review from the Court of Appeals that are accepted at the United States Supreme Court. And not all Court of Appeals decisions are even making a request for review. So most decisions stop at the Federal Court of Appeals and never make their way to the United States Supreme Court. This case, however, is unique and it's different. And I believe no matter which way the court rules at this level, it will go to the United States Supreme Court. Obviously, if the court strikes down Obamacare, it's automatic to the Supreme Court, because when a federal court strikes down a federal statute, it's an automatic review by the United States Supreme Court. That's a no-brainer. The question is, if they uphold the law, typically it's discretionary with the Supreme Court, and in most cases, like I said, the Supreme Court doesn't review the case. But this case, everyone believes, and I believe as well, the Supreme Court would take it even if this law was upheld. Why? Because everybody acknowledges that this is a novel, unprecedented law. It's a novel idea, and it's the first of its kind in the country, where Congress has sought to force individuals to purchase a particular product. And, that presents a significant situation that's different. For example, I was thinking after the oral argument, an example between this activity and inactivity that's at issue here. The Commerce Clause, which is what Congress says that they have the authority to enact this law, regulates commerce among the states, interstate commerce, things that are manufactured and produced and traded across the state lines. That's the classical kind of idea of commerce. If you have someone that's growing wheat, and they are planting and cultivating and harvesting wheat, and then they package it up and they distribute it across the country, they're engaged in commerce, and there could be a regulation on their particular activity because they're involved in interstate commerce. But if you or I are standing in an adjoining field and we're just watching this process take place, and we're not consuming the wheat, we're not engaged in commerce. But for the very first time in history, what this law does is it reaches that bystander that's simply watching the process, doesn't care to participate in the process, doesn't consume the wheat that's being produced, and now the federal government is telling the innocent, idle bystander, you must buy and you must consume that product. The question that you have to ask is, what activity is even involved that would even allow the Commerce Clause to be used as the constitutional basis to enact that kind of law. And it's unprecedented. That's why this is so unique. It's so rare and it's so unprecedented that if Congress can do that, force the innocent bystander to buy a particular product that they choose not to buy, then the limitations on the government have simply been taken away. There are no more enumerated powers. It's no more limited government. And consequently, the government's ability is just simply unfettered.
Yeah, Matt, this is one of those things it's one of two things. It's either that they are expanding the Commerce Clause in such a way that we've never seen as a nation before, forcing you in without any other reason, any other argument that you were involved in commerce, or saying that because we've made you buy insurance, now that you're buying insurance, the chicken came before the egg there. Now you're involved in interstate commerce. Either way, this is the kind of draconian move. I don't know that people get the full impact of the reach of this. An expanse of federal power on this level pretty well erases any limitations on the federal government's ability to demand just about anything of a citizen.
Right. I mean, it no longer is a government of enumerated and limited powers. It no longer is a government that has a division between federal and state authorities. And it's no longer a government that has any relationship to the Constitution anymore. So what we have done is we've created a centralized system that has absolute control, and today can force you to buy health insurance because the government says there's a need in the health insurance market, and therefore to address it, we need to have everyone participate. Therefore, you don't want to do it, we're going to force you. The government the next day could say there's a problem within the transportation market. General Motors is having financial difficulties. We all need transportation. We need to have it more affordable and more widespread. Therefore, we're all going to force everyone to buy a particular General Motors product. It'll be cheaper and more widely distributed. And the same thing could go on with food. We're all going to participate in eating food. There are certain kinds of consequences to eating good food versus bad food. Therefore, we're going to make you eat good food. It'll reduce the health care cost and also prop up the local economy. That's the kind of unlimited power that the government would have if this case is ultimately upheld. Continue to pray for this case. We sent out an email, and in about 10 days we had over 76,000 people respond back and said, that they were praying for this case, and we've really been amazed by the overwhelming response of people praying from around the world. In fact, I have a text message from Israel that I got on the evening of the oral argument, and I'll have to read that perhaps tomorrow to you. But this case is not over, and so in the next 45 days or so is when this decision will be written and handed down. So continue to pray for this case, that it ultimately is a victory at the end of the day at the United States Supreme Court. Go to Liberty Counsel's website, lc.org. Ask for the Patriots Handbook on American Liberty at lc.org.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.